This is Bloomberg Law with June Grasso from Bloomberg Radio.
This case has always been about shocking levels of corruption. Hundreds of thousands of dollars in bribes in the form of cash, gold bars, a Mercedes-Benz. This wasn't politics as usual. This was politics for profit. And now that a jury has convicted Bob Menendez, his years of selling his office to the highest bidder have finally come to an end.
Manhattan U.S. Attorney Damian Williams basically summed up the prosecution's case against Senator Bob Menendez after a jury found the once powerful New Jersey Democrat guilty of bribery, extortion, and acting as a foreign agent of Egypt, convicting him on all 16 counts after a 2-month trial where prosecutors said he put his power up for sale. Menendez continues to maintain his innocence and says he expects to succeed on appeal.
I have never violated my public oath. I have never been anything but a patriot of my country and for my country. I have never, ever been a foreign agent, and the decision rendered by the jury today would put at risk every member of the United States Senate in terms of what they think a foreign agent would be.
Joining me is Bloomberg legal reporter David Voreacos, who covered the trial. David, tell us about the prosecution's case.
Senator Bob Menendez was accused in a sweeping corruption case of bribery, extortion, acting as an agent of Egypt, and obstruction of justice. The case centered around some explosive evidence that the FBI seized 2 years ago at his home in suburban New Jersey, and that was 13 gold bars, nearly $500,000 in cash, and a black Mercedes-Benz convertible that prosecutors said was the product of a bribe scheme that Menendez and his wife Nadine received over the previous 5 years.
The prosecution had a lot of different kinds of evidence against him. You mentioned the gold bars and the $500,000 in cash stashed around his house in closets, boots, jackets, a safe, etc. An undercover FBI videotape, a witness who flipped and testified against him. What was the strongest evidence against him?
I think the strongest evidence would have to be the cash and the gold bars, both of which prosecutors presented in court so that the jurors could see what they're talking about. There was also 3 different summary charts that included thousands of lines of text, emails, calls, meetings. They had very meticulous and detailed chronologies because this was a subtle and discrete set of interlocking schemes that really could only be understood in their totality, in which jurors saw the timeline of a number of interactions and how they fit together. And so it took time to spell that out and for the picture to come into focus. And that picture, by the end of the trial, the prosecutor said was an overwhelming case against Menendez, and the 2 businessmen tried with him, Will Hanna and Fred Davies.
David, was there any specific evidence of him saying, I'll do this for you if you give me that, quid pro quo?
There was a great deal of quid pro quo evidence that prosecutors put forward, but I would say there was no specific admission, say, on tape or to another witness in which Menendez said, yes, I know I'm committing the crime of bribery. Essentially, prosecutors built their case through inference, in which they showed that right after Menendez, say, met with the Attorney General of New Jersey on behalf of a businessman, he then called that businessman, who then texted someone else who said, I finally found peace. It's that sort of stringing together of a collection of different discrete pieces of evidence that lead to the clear inference that Menendez was engaged in bribery schemes with his wife, Nadine.
Menendez blamed his wife, and he had the benefit of being tried separately. She's going to be tried later. So there wasn't an uncomfortable situation of pointing to the co-defendant and wife who's sitting next to you as the culprit. How much evidence was there against his wife?
There was a lot of evidence pointing to Nadine as a crucial go-between who connected Menendez with the businessmen who were on trial with him and with other people less directly involved in the case. She also set up meetings with Egyptian military people and intelligence officials, and according to the government, collected gold bars and cash from Fred Davies, one of the co-defendants, and also had a crucial connection and relationship with Will Hanna, who was the other co-defendant, and prosecutors said they were like brother and sister. They were very close, and some of the most damning evidence involved the Mercedes-Benz that another businessman, Jose Uribe, gave to her, essentially by handing her a $15,000 cash down payment in a diner parking lot in New Jersey, and then making monthly payments on the car for 2.5 years. There was also evidence that Will Hanna, the other defendant in this case, gave her a no-show job in which he paid her $10,000 a month for 3 months, and he paid off her mortgage on her home in New Jersey when she was in a great deal of financial distress.
You have to tell the story about the bell that prosecutors used to show that Menendez was the one in charge, not his wife.
There was a crucial meeting behind the Menendez house in September of 2019 at 10 o'clock at night, in which Jose Uribe, the cooperating businessman who pleaded guilty, said that he came over and spoke to Bob Menendez on the patio behind their house. And this was the night before Menendez was going to meet with the Attorney General of New Jersey and make the case that state prosecutors should drop their criminal investigation of someone who was close to Uribe. Jurors heard Uribe talk about Menendez summoning his wife Nadine with a bell, and that she came out from inside the house and delivered a piece of paper where Uribe wrote down the names of the people that he was interested in. The bell became sort of a symbol of whether Menendez really controlled Nadine or not, because the Menendez defense was that Nadine was engaging in a lot of corrupt acts behind Menendez's back. The prosecutors tried to puncture that defense and say that he knew everything that Nadine was doing and that at certain times, as in the Bell incident, she was sort of under his thumb.
Menendez is now the first member of Congress to be convicted of being a public official acting as a foreign agent. Was there any evidence that he compromised the national interests of the United States?
There was an incident in which Menendez, through his wife and then Will Hanna, passed along the number of people working at the U.S. Embassy in Cairo. Prosecutors said that was sensitive information at the time and could have compromised the people who worked there and exposed them to potential terrorist attacks. The defense said that that information had already been made public in a government report years earlier, but the prosecutors countered by saying that that was old information and the current information was not public. So while they didn't actually charge him with doing harm to U.S. security interests, they certainly suggested that that was a possibility by Menendez passing along how many people worked at the U.S. Embassy in Cairo.
After the verdict, Menendez said the decision would put every member of the Senate at risk in terms of what it means to be a foreign agent. Do you know what he meant by that?
Yes, their argument was during the trial that he was not engaged in being a foreign agent, that he didn't have Egypt's interests at heart, that in fact he only had the United States' interests at heart, and that as chairman of the Senate Foreign Relations Committee, he was engaged in diplomacy, not corruption, so that all of his interactions with Egyptian military and intelligence officials were acts of diplomacy and him exercising his power as chairman of that Foreign Relations Committee. So I think what he's saying is that if you find that what I did was corrupt and acting as an agent of a foreign country, then it's going to be the case for a bunch of other senators as well.
He didn't take the stand. So what was his defense against, the gold bars and the cash and the Mercedes?
Well, the general defense strategy was to attack the witnesses through cross-examination, and his lawyers were quite effective at that. I'm sure they knew that he wasn't going to testify, so they put their case on primarily through the prosecution witnesses, although they did call a half dozen witnesses at the end. He had a number of defenses, but as you say, he had to come up with a story for the cash and the gold bars. As far as the cash went, he said that he had withdrawn cash in the amount of $400 regularly, say every 2 or 3 weeks for decades, and that would account for all the cash that was lying around his house that FBI agents received. The gold bars, he said, were gifts to Nadine Arslani and then his girlfriend and later his wife from her wealthy family in Lebanon. And the prosecutors countered that by saying that the larger gold bars that they seized bore the serial numbers that matched a list in the possession of Fred Davies, a prominent developer in Edgewater, New Jersey, who was known for his generosity and for collecting gold.
In 2017, Menendez was tried on unrelated federal bribery and corruption charges. That ended in a mistrial. Did the evidence here show that mistrial apparently didn't deter him? These schemes allegedly took place soon after?
Yes. That trial ended in the fall of 2017, and the evidence showed that the bribery plot in this case, for which he was convicted, began in early 2018. Of course, this was handled by the federal prosecutors in Manhattan, the Southern District of New York, presumably because they felt there would be a conflict for the prosecutors in New Jersey.
So now he's going to be sentenced on October 29th. He faces decades in prison on paper. What do you think a likely sentence might be?
On the most serious charges, he faces 20 years in prison. It's very rare in a white-collar case like this for a first-time nonviolent offender with a long career of public service to get anything like that kind of time. It's hard to know. I mean, we just had the conviction today. So if I had to guess, I would say maybe several years.
Thanks so much, David, for your reporting all during the trial. That's Bloomberg legal reporter David Voreacos. Coming up next, the likely demise of the National Youth Climate Case. I'm June Grasso, and you're listening to Bloomberg. It's one of the most closely watched climate change cases in recent years. Kids taking on the federal government to secure their futures. 21 young people sued the federal government in 2015, asserting that the government violated their constitutional rights by allowing decades' worth of greenhouse gas emissions to spew into the atmosphere. There were twists and turns as 3 presidential administrations fought to delay or dismiss this landmark constitutional climate case. And now, after 9 years of litigation that never addressed the merits of their claims, it appears the case is as good as over, with no viable path for the young plaintiffs to pursue. Joining me is an expert in environmental law, Pat Parenteau, a professor at the Vermont Law Graduate School. The Juliana case was filed way back in 2015. It has spanned 3 presidential administrations. Tell us the basics of it before we go into this tangled legal history.
Yeah, so this case was brought to try to establish a constitutional right under the federal U.S. Constitution under Article 14, sort of fundamental right to a stable climate, or as Judge Aiken, who was the district court judge in Juliana, said, a climate system capable of supporting human life on Earth. Now, some of us might like to think there should be such a constitutional right, but the case was brought to try to establish that in federal court. that's had almost a decade run in the federal courts, which now seems to have come to an end, although we can talk a little bit about what comes next.
And there were two different panels of the Ninth Circuit that heard this case.
Yeah, it does have a tortured procedural history.
It does.
So the original complaint really shot for the moon. It asked for a plan to reduce carbon emissions basically down to zero or net zero by a date certain, with milestones all along the way. For example, phasing out carbon from the electricity sector by 2030 and so forth. A very, very aggressive demand that federal courts order the federal government, both the president and the Congress, the entire federal government, order them to come up with a plan to achieve, net zero carbon emissions for the U.S. economy. Very aggressive. That complaint went to the first panel of the Ninth Circuit, and by a 2-to-1 decision, that panel decided that kind of broad, comprehensive relief was not available under our jurisprudence in the United States anyway. And so they dismissed the case on standing. They agreed that these youth plaintiffs had shown injury. Some of the injuries were physical. One of the kids had asthma, and we know climate change, by heating up the air we breathe, triggers asthma attacks. Another one of the youth plaintiffs said they were in a multi-generation ranching family and they were watching their ranch dry up. And so right down the list, the court said, yes, these individual young people have shown particularized injury, which is the first step in establishing standing. And this was a really important finding, the court agreed that the actions of the federal government, not just inaction, but the actions going back 5 administrations, Democrat and Republican, had been making the situation worse by continuing to promote and develop fossil fuels, et cetera. And so therefore, the plaintiffs had shown that their injuries were being caused or contributed to by the actions that the federal government was persisting in taking. So that was 2 steps towards proving standing. It was the third step that tripped them up. It's what we call redressability, which means assuming this injury, assuming the actions of the government are making the injury worse, what can the courts do about it? And that's where the first panel of the Ninth Circuit said, they threw up their hands. We simply don't have the authority under our constitutional system of government. That's a matter for the legislature and the executive branch to work out. The courts can't simply order it. So that was the first decision. Following that decision, attorneys representing the youth plaintiffs went back to Judge Aiken and filed a motion to amend this complaint to only seek declaratory relief. So no injunction, no comprehensive plan, just tell us, do we have a constitutional right to a safe climate or not? And if not, of course, why not? So Judge Aiken agreed they should be able to amend the complaint. She based her decision on the fact that the original Ninth Circuit decision did not say dismiss the case with prejudice. They didn't use that magic language, dismissal with prejudice. So Aiken said, in the absence of directing me to dismiss it with prejudice, I think I have the discretion to allow the amendment. And since all they're seeking now is a declaratory judgment, that basically cures what she saw, at least, as the defect in the original complaint that the first panel of the Ninth Circuit said was fatal.
That first panel of the Ninth Circuit was comprised of 3 judges appointed by President Obama. The second panel was a different story. So
now we come to the second Ninth Circuit decision, just recently, within the last year, in which now we're talking about 3 Trump appointees to the Ninth Circuit. That comprises the second panel. And they excoriated Judge Aiken. They said it was basically arbitrary, almost outrageous, perhaps, for her to not read the original decision of the panel, the first panel, as a requirement that the whole case be thrown out, lock, stock, and barrel. So that's what the second panel said, and that was a 3-0 decision. And then we come to the very last gasp, which is after this second Ninth Circuit panel throws the case out, the youth plaintiff lawyers asked for the full Ninth Circuit to review the case in what we call en banc, where you have actually not the full Ninth Circuit, because there are over 30 judges on the full Ninth Circuit, but it would be a much larger panel, typically 12 or 13. 13, I think, judges sit on that kind of a panel. But it takes at least one judge of the Ninth Circuit to request a vote on whether to take the case up before an en banc panel, and they didn't even get one vote. So that's where we are today. The case has been dismissed. There's no further appeal to the Ninth Circuit. The only remaining avenue for appeal would be to file a petition for certiorari or review to the U.S. Supreme Court, something that terrifies a lot of us.
I mean, it's been at the Supreme Court twice on procedural issues, I think.
It went up twice on what's called a writ of mandamus, which is an extraordinary remedy. The Supreme Court never granted the petition for mandamus, but they, in two different orders, and particularly the last one written by Chief Justice Roberts, they made it crystal clear that this case should be dismissed. Roberts basically was speaking directly to Judge Aiken, and he was saying to her, you need to take another look at whether this case should be certified for review by the Ninth Circuit, and the Ninth Circuit should look very hard at whether a case of this magnitude and scope belongs in federal court. So, not too subtle message to the lower courts, get rid of it.
I guess the Ninth Circuit heard that message. The young plaintiffs asked for a rehearing before a full panel of the Ninth Circuit. That would be 11 judges. But no judges requested to vote on whether to open the dismissed case once more and denied their request last week. It appears the only thing the plaintiffs could do now is file a cert petition with the Supreme Court. But is that wise to do with this Supreme Court, or is it better just to end the case where it is?
Right. There's no way the Supreme Court is going to take this case for any other reason than to do further damage to cases being brought to try to seek remedies for climate. They could even revisit the Massachusetts versus EPA case, which turned on a 5-4 vote on whether there was standing to challenge EPA's failure to regulate greenhouse gas emissions. And the majority in that case are now gone, basically. So it's a totally different court. So the only reason this Supreme Court would take the case would be perhaps to review Massachusetts versus EPA and almost certainly issue a decision that would slam the courthouse doors shut once and for all on plaintiffs seeking remedies for climate change.
Every administration, the Obama administration, the Trump administration, the Biden administration, some which we consider friendly to environmental causes, has been aggressive, so aggressive in preventing this case from going to trial. Why?
Yeah, I've said from the beginning, why not have the trial? My goodness, if they hadn't fought so hard all the way back to Obama, they could have had the trial over with. And Judge Aiken was not saying she was going to find in favor of the plaintiff. She was saying you take litigation one step at a time. The first question is their standing. The second question is their liability. And what she was saying is we'll have a trial and I'll make a decision based on the trial. So at a minimum, I thought, why not let them have a trial? You know, the Department of Justice is hired and paid for by us, the taxpayers, to defend the government in court. That's why we have courts. Courts are supposed to say what the law is, so do it. So, I mean, this all could have been avoided, in my view, if they just had the trial long before now. Either Judge Aiken would have ruled against the plaintiffs in one form or another, or the case could have gone up on appeal on the basis of a trial record, including all the evidence in support of what the youth plaintiffs were arguing and in support of what the government was doing to make the climate crisis worse. And wouldn't that have served some public purpose to have a record like that based on a trial tested by the evidence? I think the answer to that is yes, it would have benefited from that. Even if the end result was probably going to be no determination of a constitutional right. I think that's fair to say, even with the Supreme Court we had before the Trump appointees. But certainly now, there's no chance that this court would ever recognize such a constitutional right. Hell, they're busy revoking constitutional rights like Roe versus Wade. So we weren't going to get a favorable decision out of this Supreme Court no matter what. But at least having a trial for no less than at least historic purposes, would have made the case what the dangers were, what we're doing to these young people, and what we're not doing that could avoid some of the worst consequences.
So, Pat, is the Juliana case dead then?
I think it's dead. I think it's time to move on. I know my dear friends at our Children's Trust are very reluctant, and I understand why, to give up on it. But they've got other avenues, and perhaps we should be talking about some of those. This isn't the end of the story on young plaintiffs asserting constitutional rights. I think it is the end of the road doing so in federal court.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Pat Parenteau, and we'll discuss some of the successes in climate change cases brought by young plaintiffs. I'm June Grasso, and this is Bloomberg. The historic climate case of Juliana versus the United States appears to be at an end after 9 years of litigation that never addressed the merits of the case. The claims by 21 young people that the government violated their constitutional rights by allowing decades' worth of greenhouse gas emissions to spew into the atmosphere. But that case has inspired other young people to sue over climate change, and some of those cases have been more successful. I've been talking to environmental law expert Pat Parenteau, a professor at the Vermont Law Graduate School. So, Pat, in Montana, a group of young people sued the state over its failure to consider climate change when approving fossil fuel projects, and that became the first case by young environmental activists to go to trial.
That's right. And it's the first ruling, this by a lower court in Montana, Judge Seeley, issuing the first declaratory judgment. In that case, unlike Juliana, the court said, all I'm going to consider is a request for declaratory judgment. So this judge was smart enough to limit the case right from the get-go. But her ruling, backed up by 200 separate factual findings, the most detailed findings of fact we've ever seen in a climate case, on science, on technology, on the physical and mental, emotional effects on these young people from the effects of climate change, particularly in Montana, and also challenging Montana's really, how can I put this delicately, arbitrary statute which prohibited state agencies from even considering the climate change effects of licensing, permitting fossil fuel development from pipelines, from coal mines, from coal-burning power plants, etc. So that's what the youth plaintiffs in the Held versus Montana case were arguing. Your energy policies are making the situation worse, and you have a law on the books that's blinding the agencies to the consequences of what they're doing, not only to Montana's environment, but to us as the future generation that has to live with all of this. So her decision was historic, and that was then taken up on appeal. The Montana Supreme Court has now heard oral arguments on appeal. We're waiting for a decision from the Montana Supreme Court.
The arguments before the Montana Supreme Court, were they also procedural based on whether or not the youth plaintiffs had standing?
Well, standing is at the heart of that case as well. The state is not challenging the injuries that the plaintiffs are claiming, including, there was a lot of medical testimony in this case. For the first time, you had psychiatrists taking the stand saying, I have conducted an extensive interview of these plaintiffs, these young people, and made a diagnosis, a medical diagnosis, that they are suffering trauma. Some people have labeled it climate trauma. I mean, sports teams in the summertime are precluded from playing soccer and other sports because of the heat, and particularly because of the wildfires blowing toxic smoke all over the place. So, for example, the plaintiffs were saying, what's my future going to be in a world like this that I see happening right before my very eyes? So there was no argument about injury. The state focused its argument on the fact that, your injuries can't be caused by emissions from Montana because our emissions compared to global emissions, which are about 40 billion tons a year, are just a drop in the bucket. They're too insignificant to matter. That was one of their primary arguments. Their second argument was, and by the way, requiring us to consider the climate change effects, assuming we could even figure out how to do that, won't make any difference. This was really an astounding argument because we've never denied a permit for pipelines or other coal mines or other fossil fuel development, and we won't because we can't. because the state law that requires this kind of environmental assessment of climate change effects, it's a version of our National Environmental Policy Act called the Montana Environmental Policy Act, or MEPA. Their argument was MEPA, even if we wrote an extensive environmental impact statement documenting all of these impacts, we can't use that to deny permit for this development. Therefore, the court can't award any meaningful relief. Really astounding argument that, by the way, I don't think the Montana Supreme Court is going to accept.
And then you have in Hawaii the first time a state has settled a lawsuit with a group of young people over climate change.
That's right. That's called the Navahine case. And in that case, our Children's Trust was representing yet another group of young people, and they were challenging Hawaii's transportation system. Of course, Hawaii is an archipelago of I don't know how many islands. So a very complicated, matter for the state to deal with. And so this case was teed up for trial starting in last June and just settled. They postponed the trial so they could negotiate an agreement, which they reached. Now, the difference between Montana and Hawaii is night and day. So Montana is a very hard right Republican state, Republican governor, Republican AG, Republican legislature. Hawaii is the exact opposite. It's a liberal, democratic, progressive government, governor, legislature, attorney general, and they were anxious, frankly, to avoid a trial because they agree with the plaintiffs that climate change is a problem getting worse for Hawaii. We saw what happened in Maui, unfortunately, with those wildfires, contributed at least in some part to what's happening with the weather out there. So that's the first settlement agreement where a state has agreed to make changes not only to their transportation policies, but actually start ramping up significant investments where they can in mass transit on the Big Island and Oahu. Air travel is the biggest problem. So trying to figure out how are you going to deal with island hopping through airline travel is going to be a real challenge. But the point is they reached an agreement. They've got at least an initial plan for how to begin to reduce emissions from the transportation sector, and then they'll go from there.
Does it make a difference that in Hawaii, the Constitution guarantees the right to a clean and healthful environment, and the same in Montana, that Constitution also guarantees that? So does that make these two states different from most others?
Yes, it does. And you're right. There's a right to a clean and healthy environment provision in both Montana and Hawaii. Hawaii also has one of the strongest public trust doctrines in the United States, and that was a factor in the case as well. Other states that have a green amendment, New York, Pennsylvania, I would anticipate we're going to see lawsuits in those states trying to seek similar judgments from the state courts under those constitutional, what we call green amendments. And frankly, I think there's a reasonable chance of success in both New York and Pennsylvania. There are other states with these green amendments. Believe it or not, Alaska has one, Louisiana has one, Florida has one, and our Children's Trust has litigation going on in all three of those states. In fact, has litigation in every state. So we'll see what happens. But I think they're going to win on appeal in Montana. I think that's going to set a precedent. It's not going to have a lot of immediate practical effect in Montana because of the politics, but it is going to be a building block for other state courts to build on. No court likes to be the first to make a decision like this, but many courts are prepared to be the second or third to do that. The settlement in Hawaii shows that what the plaintiffs are seeking is not unreasonable, is not undoable, but with the right kind of political receptivity, things can be done to improve the situation. So it's early days of this form of state-based climate litigation. But for me, that is the future. That's where climate litigation, if it has some chance of success, that's where it's going to find it.
I want to touch on another case not involving young plaintiffs, because Honolulu is a plaintiff in a climate case against Sunoco and other big oil companies, accusing them of misleading the public by concealing their understanding of the devastating effects of global warming. So now a coalition has appealed that decision to the Supreme Court. And the Supreme Court has asked the Biden administration for its views. Does that mean some of the justices are interested in this? And how bad would it be if the Supreme Court took this case?
Yes, it does mean that some justices are interested in this. There was an earlier petition from the Eighth Circuit Court of Appeals in a case brought by Minnesota where the Supreme Court declined to take the case, but Justice Kavanaugh wrote a short dissent saying, I think some of the issues being raised by the oil industry deserve review in our court. So he has signaled an interest in these cases. And by requesting the views of the Solicitor General, which, of course, this court may simply ignore, it has before, that does say that there's some interest, at least, in thinking harder about whether now is the time to review these cases. This is the case from Honolulu. It hasn't gone to trial, so there's no final judgment. I've made the argument in writing that I don't think the Supreme Court actually has jurisdiction over a case from a state court where there's been no judgment. It's what's called an interlocutory appeal, preliminary case. So what I'm hoping is that the court declines to take it. They don't need to take it. This court probably is going to have the final word on these climate liability cases. There are now about 34 cases pending in state court across the country, brought by states, cities, counties. I think at some point there is likely to be a verdict, frankly. I don't know which one. There's going to be wins and losses probably along the way, but at some point, and maybe Hawaii will be one of those, I think there will be a verdict and a final judgment, and I think the Supreme Court will at some point take the case to determine whether or not, as the oil industry is arguing, there is no remedy for climate change damages, period, in no court, not federal court, not state court. That's their ultimate argument. And they're going to argue something they call absolute preemption, that courts have no business, no jurisdiction, no authority to adjudicate claims for damages against the oil industry. And at some point, I think that is going to have to be settled by the U.S. Supreme Court.
A lot of climate litigation ahead of us. Thanks so much, Pat, for helping us understand the landscape of climate litigation. That's Professor Pat Parenteau of the Vermont Law and Graduate School. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.